there a Dayglow 15 marker at the top of the pillar when you got there?
No, the Dayboards, which would have been number 15, it's a green square, and there should have been 2 of them on the top of the marker, so that if you're navigating from north to south, you could see one, and it tells you the east side of the channel. And then if you're navigating from south to north, you would see the opposite one as you're traveling northbound, and it'll let you know the east side of the channel.
The marker had no sign on it when Florida Fish and Wildlife Lieutenant Manuel Palmarez descended into the waters at Cutter Bank Channel the morning after the crash. He documented the steel pylon that George Pino's vessel had struck. He photographed it from every angle. He noted the bird droppings coating its upper surface. And then he confirmed something that would matter far more than the prosecution anticipated. The green square dayboards, the 3-by-3-foot reflective wooden signs bolted to each face of that marker, the navigation signals that boaters rely on to identify channel boundaries, were gone. The pylon was bare, and nobody in the courtroom stopped to ask how long they had been missing.
Sort of like a whiteness at the top of it. What is that?
That is the feces of birds, water birds that land on the top of the marker.
You could say bird poop if you want.
I was trying to be more professional, but that is the birds land on there. They go to the bathroom, and it ends up making those marks on the piling.
And I should ask you, what is supposed to be on top of this?
On top of that, if you look at may I look at them?
Yeah.
If you look at the markers, you'll see there's like a rectangle in the middle of the feces, and that would be where there would be a dayboard flush against one side of the piling. And then if you look from the south coming north, you would see the same thing. The best I could describe it is a rectangle where there's no feces, and that's where the dayboard would be. That's why there's no feces there.
So basically,
there's no white.
There's going to be a dayboard on one side, a dayboard on the other side, and the pylon in the middle?
Correct.
By the end of this video, you will understand exactly why a missing navigation marker changes the legal meaning of culpable negligence under Florida law. On September 4th, 2022, George Pino, 57, was operating a 29-foot Rabalo vessel through Cutter Bank Channel in waters between Miami, Dade, and Monroe counties, Florida, when the boat struck channel marker 15, capsized, and killed 14-year-old Lucy Fernandez. Pino was charged under Florida Statute Section 327-33 with culpable negligence in the operation of a vessel, a criminal standard requiring proof that his conduct demonstrated a reckless, conscious indifference to the safety of others. The case was prosecuted by the state of Florida. The dive scene investigation was led by Lieutenant Manuel Palmarez of the Florida Fish and Wildlife Conservation Commission, a 29-year veteran of the agency and a certified member of its dive team.
The vessel.
So let's talk about how that happened and the information that you have. Were you working on the day of the crash, September 4th, 2022?
I was not working on that day when the event occurred. I was notified afterwards.
How did you learn about the crash?
I believe I was called either to my personal phone or my work phone, notified, and then I would have come out shortly after that on the clock and responding to phone calls and trying to gather information and see what needed to be done at that point.
Where did you respond?
Initially, I was just on the phone gathering information because I didn't know where to go until more information started coming in. The location of the accident was Cutter Bank, which is a remote area that even if I left right away, I wouldn't have been able to go to. So it was more beneficial for me to get additional information and see what was needed before I left.
George Pino was not a reckless man by the account of every witness who knew him. He had navigated Cutter Bank Channel safely on numerous prior occasions. He had his wife, his daughter, and her closest childhood friends aboard that boat. He accepted, without dispute, that he was responsible for getting those passengers home. What was in dispute was whether the 9 seconds in which he lost situational awareness and failed to turn the wheel constituted criminal recklessness. the kind of conscious indifference to human life that the law reserves for criminal prosecution rather than civil accountability. The financial cost of defending a felony charge in Florida runs into six figures before trial begins. George Pino paid that cost while already carrying the weight of Lucy Fernandez's death. The prosecution's case rested on a theory of criminal recklessness built around speed, inattention, and a GPS track showing 9 seconds of visible approach to marker 15 before impact. The state called Lieutenant Palmarez to establish the physical scene: the capsized vessel, the damaged pylon, the underwater documentation. His testimony was methodical.
So I was also part of the dive team. So part of our duties was to document the scene or the crash site. We had come up with a game plan to respond out there on one of our patrol vessels. 3 members of the dive team, I believe it was Officer Oscar Saavedra, Lieutenant Ryan Smith, and myself were dive team members. And there was an officer, I don't recall at this point, that was driving the vessel, shuttling.
He confirmed he had been with FWC for 29 years. He confirmed he was a trained and certified diver. He confirmed that FWC had maintained continuous custody of the crash site from the night of the accident through the following morning's dive to preserve chain of custody.
Drive to?
Initially, I just stayed at the house making phone calls, coordinating. Eventually, I ended up, I believe I went to Walmart and bought water, and I believe one of my counterparts bought food because at that point in the evening, we had to keep officers keeping watch on the vessel because the vessel was overturned in Cutter Bank, adjacent marker 15, and we knew we weren't going to be able to recover it that day, so we needed to maintain custody of the vessel and have somebody watching it overnight, so we had to make arrangements.
Okay, let me stop.
Sorry.
He confirmed that the vessel was photographed from every angle above and below the waterline. He confirmed the damage was concentrated entirely on the starboard side of the vessel, consistent with a direct strike. And then, in answer to a straightforward question about what he found at the top of the pylon when he arrived, he confirmed that the dayboards were missing. There were no green marker signs on marker 15. The pylon was a bare steel pipe. The prosecution moved on without a single follow-up question about when those signs had last been in place. Most people watching that moment assumed it was a minor procedural detail about a navigation aid. It was not. The absence of the dayboard signs from marker 15 is the most legally significant physical detail in this entire case for one reason. The prosecution's GPS evidence showed the vessel's track approaching marker 15, and the defense had already established that the same GPS device placed marker 15 up to 15 feet from its actual location. A bare steel pylon on a calm afternoon without its reflective green identification boards in a narrow funnel channel where boats are traveling at highway speeds is a substantially different navigation hazard than a properly marked channel post, and whether that difference matters legally is precisely the question the prosecution chose not to ask.
The Dayboard markers, what are they made of?
They're typically made of plywood, and they have some kind of laminate adhesive sticker on the face of it that faces out from the marker. And it's typically has some kind of reflective material so that and when vessels navigating at night, the operator could see the markers and make it easier for them to identify the markers ahead.
What are the dimensions of the placard on, what are the dimensions?
I contacted Coast Guard, and they advised me it would be 3 by 3 feet by 3 feet. And I brought a piece of cardboard.
Wait.
Oh.
Under Florida Statute Section 327 and 33, culpable negligence in vessel operation requires proof that the defendant's conduct was grossly careless, flagrant, and demonstrated a conscious disregard for the safety of others, a standard that is legally and constitutionally distinct from ordinary negligence, which is the basis for civil liability. In plain English, the difference is this: civil negligence means you failed to be careful enough. Criminal culpable negligence means you knew the risk and chose to ignore it anyway. The prosecution was required to prove the latter, and the physical condition of the navigation marker Pino struck, stripped of its identification boards, its GPS position recorded 15 feet from its actual location, goes directly to whether a boat operator traveling a route he had taken many times on a calm day with no posted speed limit could be said to have consciously disregarded a risk he knew existed. The legal question this raises is whether the prosecution ever investigated the maintenance history of Marker 15 before filing felony charges. The channel marker had no dayboards. That fact was in the prosecution's own evidence. Their witness confirmed it, and they never asked why.
In this image, you can see the T-top on the bottom of the bay. You can see the grass. Again, you're looking at the underneath. What's on the grass would normally be facing the sky. You can see a telephone right here, which is underneath of the T-top. This is the front windshield. We got a side windshield here and a side windshield here. You see the top of what would be the console and the compass there. So that's pretty much the boat upside down from front to back.
Now, how about in states 48? What are we looking at here?
So again, this is the helm area. So now you're looking from what would be the seating or operating position. You got the steering wheel, you've got the throttles, which you control with your hands. You've got 2 GPS units right here. They're hard to see because they're dark right now. All the switches on the console. Again, the front windshield.
The prosecution did not establish when the dayboards were last confirmed in place. They did not call a Coast Guard representative to address maintenance records for Marker 15. They did not address whether FWC or any agency had any obligation to report or repair the damaged navigation aid before or after the crash. They did not ask Lieutenant Palmarez whether the absence of those boards would have affected a boater's ability to visually identify the marker at speed. Under Florida Rule of Criminal Procedure 3.220, the prosecution has an obligation to disclose all material evidence, and the physical condition of the marker they alleged Pino failed to avoid was material evidence they possessed and did not fully develop. A properly prepared prosecution would have secured the maintenance history of Marker 15 before charging, addressed the missing dayboards affirmatively in direct examination rather than allowing the absence to pass without explanation, and established through expert testimony whether a bare steel pylon in that channel presented a different visual profile than a properly marked one.
So take me through that. What do you do? How do you go about doing this type of a dive?
So the divers on this day were Lieutenant Smith and I, and then we always leave a diver on the surface in case there's any kind of emergency. That person can immediately get in the water and render aid if there's an entanglement or air issue or some kind of emergency, unforeseen event. That officer is on the vessel paying attention to us, that diver, ready to go and enter the water if he needs us, if we need him.
Okay. And do you each take turns just diving right in?
No, we go in together. Always go in 2 people minimum for safety. And then on that particular day, I was recording and taking pictures with a GoPro camera, underwater and above the water.
Okay, so tell us a little bit about the GoPro camera. Is that something you're holding, or is it on your person? How does that work?
It's a small camera that's in an underwater case, so it can be taken underwater, and I'm holding it. Prior to doing anything, I went around the vessel to get a 360 to see what was done or what was there before anything was touched. And I believe we did a second loop around the vessel to document everything before we touched any of the items that were on the vessel or around the vessel.
Now,
The cost of that failure, to George Pino, to his family, to the years and tens of thousands of dollars consumed by a prosecution built on evidence that raised more questions than it answered. Is the cost the state's charging standard is supposed to prevent? What the defense's examination of Lieutenant Palmarez accomplished was the quiet introduction of a physical fact that the prosecution never fully explained. The marker George Pino struck did not have its identification signs on it. Under Florida Statute Section 32733, the culpable negligence standard requires proof of conscious disregard of a known risk. The cross-examination strategy in cases like this is built to undermine the prosecution's ability to establish that mental state, not by denying the crash happened, but by introducing physical conditions that a reasonable person could not have fully anticipated. The missing dayboard is exactly that kind of condition. Most people assume that a channel marker is a channel marker regardless of whether it has its signs attached, that a steel pylon is a steel pylon, and that running into it is the operator's fault no matter what. That assumption, while understandable, is not what Florida's culpable negligence standard asks the jury to apply. The law asks whether this specific operator, on this specific day, in these specific conditions, consciously chose to disregard a risk he recognized. A marker stripped of its identification boards, mislocated by up to 15 feet on the GPS device the prosecution used as its primary evidence, is a materially different factual predicate than a fully marked, accurately mapped navigation aid. The prosecution argued that culpable negligence was established by the combination of speed, inattention, and the GPS track showing 9 seconds of approach time. George Pino had 14 passengers aboard, including children. He was operating at 47 miles per hour in a vessel rated for higher speeds. There was no posted speed limit in Cutter Bank Channel. Their own investigator confirmed it. But the prosecution argued that the absence of a speed limit does not eliminate the duty of care owed to passengers, that a reasonably prudent boat operator would have maintained situational awareness through a narrow funnel channel regardless of GPS fallibility, and that 9 seconds is enough time to turn a wheel. Lucy Fernandez was 14 years old. She was on that boat because her family trusted George Pino. The state asked the jury to hold him criminally accountable for the choices that led to her death. The defense answered with equal precision. The GPS the prosecution relied upon placed marker 15 feet from where it actually stood and had registered the vessel traveling at 77 miles per hour. A physical impossibility. The dayboards that would have made marker 15 visually distinct from a bare steel pole were missing when FWC arrived the next morning. No one established when they were last in place. No one established whether Coast Guard had inspected that marker before the crash. The defense argued that culpable negligence requires conscious disregard of a known risk, and that the physical evidence raised a genuine question about what George Pino could have known in those 9 seconds, given the conditions that actually existed in that channel on that afternoon. The one question neither attorney had fully resolved for the jury was this: does the absence of the dayboards from marker 15 establish a condition that a reasonably experienced boat operator could not have fully anticipated? And if so, does that condition shift any portion of the legal analysis in a way that makes criminal culpability harder to prove beyond a reasonable doubt? The jury returned a verdict of not guilty. The verdict was legally correct under Florida Statute Section 32733, as that standard has been interpreted by Florida courts. Culpable negligence in Florida requires proof of a mental state, conscious indifference, that goes beyond the failure to prevent a foreseeable accident. This is the same foundational principle the United States Supreme Court examined in Morissette v. United States 342 U.S. 246 1952, where the court established that criminal liability in American law requires proof of a guilty mind, a mens rea, and that courts must not casually dispense with that requirement simply because a harmful outcome has occurred. Applying that principle to the evidence in this case, a boat operator with no posted speed violation, navigating a route he had taken safely many times on a calm day with a GPS device that the prosecution's own expert acknowledged was computationally fallible, striking a channel marker that had no identification boards attached. The jury's conclusion that the state had not proven conscious disregard beyond a reasonable doubt was not merely defensible. It was the law applied correctly. Every person who operates a vehicle, a boat, or any equipment in a regulated environment carries a legal duty of care. That duty is real and it matters. But the criminal law draws a deliberate line between the failure to meet that duty and the conscious choice to disregard it. And maintaining that line is what prevents the criminal justice system from becoming a mechanism for prosecuting every accident that results in a tragedy. Lucy Fernandez deserved justice. Her family deserved a full accounting of every factor that contributed to her death, including the condition of that channel marker. What they deserved was an investigation that asked every question the physical evidence raised before charges were filed. George Pino will carry what happened for the rest of his life. The jury decided he should not carry a felony conviction alongside it. Coming next, we examine a case in which a vessel operator was convicted after prosecutors established not just what happened, but what the defendant demonstrably knew about the condition of the waterway before departure, and how that single evidentiary distinction changed everything about how the culpable negligence standard was applied. Was the prosecution's decision to charge George Pino with a felony a necessary exercise of the state's obligation to seek accountability when a child dies? Or was it an overreach that filed criminal charges without fully investigating the physical condition of the navigation marker at the center of the case? And if the dayboards were missing before the crash, and that fact was never fully pursued, what obligation does the state carry to the families of everyone involved when it brings charges it cannot fully support?